Good evening, everybody. Jonathan Ginsberg here. I hope you are all doing very, very well. I've had a really busy week this week, had 5 hearings, all by telephone. I think one was video and the rest were by telephone. So it was pretty exhausting, but I think they all went pretty well. And, one thing I can just tell you from doing all these hearings is that judges are really, really, really focusing on objective evidence, MRI evidence, ultrasound evidence, cardiopulmonary testing evidence. The more that you have, the better it is. When you have basically a condition and it's basically what you say, judges are really, really skeptical. I think there's a lot of pressure only to focus on cases or to approve cases where there's objective evidence. So for whatever it's worth, objective evidence is really, really kind of hit home for me this week, just how important that really is. So, let's jump into the questions, shall we? Ron Kimbrough is on SSDI and 100% permanent total to the VA. How do I keep from having to pay for medical insurance? I've already had VA medical and you're keeping it. I think at this point you need to talk to a Medicare specialist. And I think what Ron's getting at is when you are approved for Social Security disability, 2 years, 24 months after your first payment, after the date of first payment, realize there's a 5-month waiting period in there. So the first payment, 2 years after that, you become eligible for Medicare, and Social Security will automatically start deducting a premium from your disability benefit. So I think what Ron's asking is, how does he avoid having that happen? Honestly, that is beyond what I do. What I would tell you to do is contact Cal Hero, Hero, at MedicareMall.com, info@MedicareMall.com. He is the person I turn to for Medicare issues. And he is an insurance guy, I'll tell you, but he's also very, very helpful to my clients in answering questions about Medicare. So, Ron, I would tell you to reach out to Cal Hero, info@MedicareMall.com, and he should be able to give you an answer about how to avoid paying for Medicare when you've also got VA. Because I agree, it doesn't make any sense to double pay. Christina, one of our regulars from way, way back. Hello from California. Hello, Christina. Hope you're doing well. Thank you for tuning in as always. Blue Z, waiting on approval for my kids' auxiliary payments. I was 100% approved through my, looks like your onset date. Will my kids get back pay to that date? Yes. And realize with auxiliary benefits, sometimes people get confused about this. It does not reduce your benefit. It's in addition to your benefit. It's a percentage is how the calculation is. So usually about 25% of what you get, but it doesn't reduce what you get. Now, there is something called a family max. And basically, if you had, let's say, 8 or 9 children, they would not each get 25%. There is a maximum that you would get as a family. And I believe, if I'm not mistaken, it's assuming 2 kids, maybe 3 kids. So if you have 2 kids and you get on, both those kids are going to get a benefit equal to 25% of yours. If you have 3, I don't know if it's 2 or 3, but beyond that, I think it starts to reduce the percentage to them. So they've got to go through and they've got to confirm that these are dependents, that they meet the requirements for auxiliaries. And once they do that, they should get their check. And by the way, the attorney's fee is based on all the payments made. So I've had situations where, let's say that the attorney's fee is $2,000 for my client, then there'll be another $500 comes to me because the auxiliaries get paid. So it's basically the cap is on everything. So right now the fee cap is $9,200. Not a lot of cases go that high, but that's the fee cap. So it would not be $9,200 for you and $9,200 for the kids. It would be $9,200 total for the family. But you would pay attorney's fees for the auxiliaries if you had not reached that $9,200 amount. Again, usually it's going to be about 25% of what your benefit is, but that's sort of how you calculate that. And again, sometimes it takes a while for them to do the calculations and to figure it out. They're really, really backlogged, and these type of calculations have to be done by hand, or they have to be done in a special process. So you may see your money and your auxiliaries may not see it for 6 months. That's just because of how backlogged everybody is. Spine surgery journey, 1 year disabled and off work. Employer had to pay me out on all vacation because I've been disqualified. Do I need to report? the Social Security will see that. Now, again, that does not count for SSDI. That does not count as earned income because it is vacation time. So it's not counting against you. And so for purposes of an onset date, they're going to look at the last day you actually showed up at work. You're able to do the work at SGA, substantial gainful activity level. If you got paid and you're getting paid vacation pay, that does not count as earned income. So your onset date can be before the payout of your accrued vacation or sick time or things like that. So really onset is going to be the day you stop physically going into work. Even if you got payment thereafter for accrued vacation or sick time, does not matter. They're focusing on the last, because realize disability is defined as inability to engage in substantial gainful activity. So when you last engaged in substantial gainful activity, that's the onset date. And the fact that you got paid after that for something not related to earnings, not for earned income, doesn't count. Just like, again, for SSDI, this is not SSI, but SSDI, if you have rental income, dividend income, that does not count against you as well. So be aware of that. It is, again, they're focusing on when you actually left work. So spine surgery was disqualified from your job, going in for your third back surgery. SSA called and said I should have it rolling really soon. They finished my work history, 8-month waiting. And I will tell you, interesting, you mentioned you've had multiple surgeries. One of my cases this week was an interesting case. It was a second hearing, actually a third hearing on this case. My client was in her 40s, a very nice woman, and she had undergone 3 back surgeries like in 2019. And basically, the first surgery was not successful. The second was a revision. Then she had another herniation because all the pressure on the level below where they had the surgery caused another disc herniation. So she has what is called post-laminectomy syndrome, also called failed back syndrome. And realize 42 years old. And the judge basically said, when someone's had 3 surgeries and they're not better, I'm going to consider that failed back, and they're probably not getting better. And the judge went ahead and approved it. And what made this case a little bit unusual was our date last insured was, I think, sometime in 2022. So I'm having to argue that my client was disabled after her 3 2019 surgeries, and really she has not had a lot of treatment thereafter because there's not much they can do. And she had some issues with insurance and payments and things like that. But the judge is going to go with it. The judge had a medical expert come testify. And this is, again, a little bit unusual. The medical doctor wanted to look at the record. The judge wanted to hear from him. And what actually happened at the prior hearing was the judge, after the hearing, sent the medical record out to a medical expert to review it and to answer questions. And the medical expert that they chose, or was on their panel, basically said that my client had a lot of capacity. She could work. She wasn't disabled. But it didn't make any sense. So I challenged it. I responded to it. I have a right to do that. And basically said, this doesn't make any sense. There's no basis for this opinion. I want a supplemental hearing. Judge was like, okay, you're entitled to that. Well, that doctor was not available. So another doctor came on who was a little bit more reasonable. And I got him to admit that, he basically said, well, I think that she could do some things with this, but, he admitted that the subjective problems, the complaints of pain, were not something that he could really talk about or contradict based on the record. So I said, I made a list of all the complaints my client had about sitting, standing, walking, pain from doing laundry, things like that. And so I read him this list. I said, is it unreasonable for a person who's had these 3 surgeries and has failed back syndrome to have this level of complaint? And he admitted, because I can't say yes or no, but it would not be beyond the realm of possibility. It's not unreasonable for that. And the judge basically felt like that was sufficient to, go ahead. And he said, I'm going to go ahead and approve it because I think that, that's reasonable to believe that she would have these problems after 3 failed back surgeries and epidurals and facet injections. And they're talking about a spinal cord stimulator, which she can't afford, but the judge is going to approve it. So this is a case a little bit unusual. It's a younger person, 40, started out 39, 40, 41, 3 hearings, medical expert testimony, but we stuck with it. We kept objecting to their trying to not pay it, and finally the judge backed off and is going to pay it. So, that's one of the things that, as an attorney, I try to do is I try to spot, okay, what is my argument here? And basically I made the argument that her capacity to work had been so reduced by the symptoms and the side effects of medications and the physical limitations she had that she would not be able to get through 8 hours a day, 5 days a week. And the judge was agreeable to it, which is good, as he should have been. Okay, Trish Wade. Hello, Trish Wade. How are you doing? I hope you are doing well. Susan Schmidt. Good evening. I got this response of my congressional inquiry. I know I tell people that if your cases are delayed, reach out to your U.S. Senator Representative and ask for a congressional inquiry. So basically what she got back was the medical evidence of record, they call it an MER, and the consultative evaluation reports are in, and the case has been referred to medical review. And what that basically means is that the adjudicator has obtained medical records, has sent Susan out for a consultative evaluation or 2, and that's all come back in. Now the case is being sent out to a medical doctor that works with Social Security to do a review. And that doctor, and realize it could be a pediatrician, it could be a podiatrist. It doesn't need to be an orthopedist. It may not have anything to do with the problem that you're dealing with, but it's a medical doctor of some type. And they're going to look at it and make a recommendation to the adjudicator as to whether the case should be approved. And this is all in the A section of the record. And I look at those, like when I'm doing my hearing prep, because I want to see what the state agency medical expert said. And, I've got to many times prove that's not correct. And so many times in my brief, I will say the state agency adjudicator said X, and this is why this is wrong, because you want to address that. That is evidence. That is a functional capacity evaluation. And judges are going to say, well, you got to, even though they're not supposed to be bound by it, many times they want to know why that's wrong. And so I just like to take it head on and I address why that's wrong. And I'll tell you the other thing I see many times is that the information that the adjudicators have about date last insured, about other medical evidence, it's wrong. I've had 2 cases in the last week where the state agency adjudicator thought the date last insured was, which means the date when the insurance coverage for SSDI ran out, was 2021. And the response was there's no evidence to show that the person was disabled back in 21. Well, if you look at the actual earnings record, okay, which is a different exhibit in section D of the file, lo and behold, 2024. And so I'm always looking for that. I'm not assuming that just because the state agency thought it's 2021 or the document I'm looking at when I'm, the summary page that Social Security generates from, as part of the record is right. You got to dig in and see that, in fact, it may be years later. And so, I've had 2 cases in the last week where the date last insured was 2 or 3 years after what they thought it was, what Social Security or the adjudicator thought it was. And I couldn't prove that disability began way back in 2021 or 22, but I could prove it began in 23. And since the person is still insured in 23, we have an SSDI case. So it can make a really, really big difference. So you can't assume anything that they have on there. And for those attorneys out there, when you're looking at, the docket report, it's going to have a date last insured. That is not gospel. Don't assume that it's right, because many times it's wrong. And I've seen it happen. In fact, I had a judge, I had a case that really taught me this not too long ago, where I'd been looking at that, but not really paying that much attention to it. And I said, Judge, I may have a problem here because of the date last insured. He goes, no, you don't. He goes, look at section D. Like, ding, ding, ding. You're right. I used to look at that all the time. Now that's part of my regular hearing. And again, I'd say 95% of the time, the docket report is correct, but 10, 15% of the time it's not. And that's just, you got to do your due diligence. And many times it doesn't make a difference, in terms of the dates. Many times the date last insured in the future, but every once in a while it can make a big difference. And I had a case today, had a case last week where it did make a difference. Okay, so Susan says that the staff member said a decision will be made in the next few weeks. That is correct. It could be a few weeks, it could be 6 weeks, but I think you're definitely in the home stretch in that regard. So that's a good thing. Okay, that was when it was me. And then Carlil Katana, one of my clients. Thank you very much. A $50 tip. That's great. I appreciate it. In fact, I just sent my son some videos to do today, which he did. So I guess he's going to be getting lunch on me for that. Actually, my birthday's coming up next week, so I'll use that for the whole family. We're going out for my birthday. I ended up paying for some reason, but we will do that. So I'll use it for that too. RD says, hello from California. Hello, RD. I hope things are nice out there. Omarchik, hello from New Jersey. Hope things are nice in New Jersey. Everybody talks about, makes fun of New Jersey, but they call it the Garden State. So there's some really nice places in New Jersey. So, I've only kind of been through a couple of times, but it'd be interesting to kind of find some places to go. Actually, I'm going to be in about 3 weeks. I'm going to be in Traverse City, Michigan for a wedding. I've never been up there. And so that ought to be really kind of interesting just to see, one of the Great Lakes and all that. So it'll be really kind of interesting. So I'm looking forward to doing that. One thing I did want to also let you know, I put this in the comments before, I'm going to put it in again. We are doing a little bit of a survey, and the survey basically is asking people to give me some information about kind of what you're looking for in terms of, legal advice and so forth. Just because, I've had a number of people say to me, I don't necessarily want to hire a lawyer right now, but, I might be interested in basically taking, kind of tapping into your brain and just getting some questions answered. I've kind of stayed away from that, but I just want to see if there's some interest in that. So I'm going to put this link in here, and so you can see it. So if you would not mind filling out a survey, I think I put it here as well. So let me, if you wouldn't mind, take a minute. I know that's we're going to have a more abbreviated name, but the next week. But if you look at the comments, you will see that link. So if you would not mind, those watching, to fill that out, that would be very, very helpful. And I tell you what brought this on is that, as you all know, AI is a really big deal these days. And so there's a way to put a lot of what I know into an AI engine. And, that would be kind of the thought would be for someone to tap into kind of what I know and ask questions, and it makes kind of interactive type of thing. And there's some really neat things. In fact, Brian Konoski, who was on last week, he has done a really neat job putting together an AI engine that I'm kind of testing right now. So, it's really an exciting time. So again, we're just trying to find out a little more about people, what they want. So if you could do that, that would be great. Okay. What does it mean when DDS says my case is a medical review? Like I said, what it means is that Social Security, the adjudicators have gathered medical evidence. They've sent you out for consultative evaluations, gotten those reports back. So there is a bunch of evidence, 500, 600, 800 pages of evidence in your file. And the adjudicators are not doctors, they're not judges. They're like insurance claims adjusters. So what they're doing is they're sending it to an expert, a medical consultant, typically a medical doctor, to look at the evidence and offer an opinion about whether you meet a listing or a grid rule, or theoretically that your functional capacity is so reduced you wouldn't be able to work. It's usually a listing or a grid rule is what they're looking for. But that is what they need to make a decision. Now, again, there's some new rules that say in some cases they don't need to send it out for medical review, but most of the time they do. So this is sort of the process. And when you see, when you log into your Social Security, my Social Security, and you see, step 3 or step 4, that's what they're talking about, is it's at the medical review. So it's somebody looking at this with a knowledgeable pair of eyes to say there is enough here to approve, or there's not enough here to approve, and the adjudicator would then deny it. I think Social Security there's a real push to find people who have strong cases and get them approved early and move those along. In theory, that's what they're telling us, because it takes out the backlog. Now, does that mean that they want to get people approved early because they got to pay out the money? No, because they want to keep the money in their account. Does it mean that the people not approved early are going to have a more difficult time? Maybe. I don't know. I mean, we've always found, and statistically, this has been pretty constant, that early approvals at initial, when somebody files an application, it's about 30%, 35% of all applications are approved. And again, most of those are people with, terminal cancer, some sort of very, very serious medical problem. So that's held pretty steady. It'll be interesting to see if that goes up next year. But, I think if you have a very, very clear case, of disability, again, especially if you've got some terminal illness or life-limiting problem, and you can get them to spot that early, then those cases, they really are trying to get people approved. Dimple Bellamy, hello, Dimple from Ohio. That's a great name. I think Dimple's been on here before, and I think you're the only Dimple I've ever met. So nice to meet you. Nice to see you again, Dimple. Maureen Shannon says, good evening. Good evening to you, Maureen. I hope you are doing well. Darren Megaha, I'm 57, GED, unskilled, 38 years uninterrupted work history, which is really good. Left knee is bone on bone, x-rays and MRI. Will need to quit work soon. What are my chances? Well, I think that, you could make an argument that if you have bone on bone in your left knee, then standing and walking for 6 hours is probably not in the cards. And if you look at the grid rule at 202.06, and I'll give you the link here. If you look at the grid rules at 202.06, you will see that a person who is limited to light work, and again, this is if you could do light work with no transferable skills, unskilled work like you've got, then you would be considered disabled. The only way for a judge to deny you would be to find you could do medium work, which means standing and walking 6 hours, lifting up to 50 pounds. So again, if your doctor is willing to say you're a candidate for knee replacement, it's bone on bone, there's really no treatment other than, narcotic pain medication, I think you've got a pretty good argument because you really can't stand. But again, it would be really helpful to have a doctor say that standing is limited to 2 hours a day, 3 hours a day. Then I think if you look at the grid rule at 202.06, I think you have a pretty good shot at winning. That's my take. Does it mean they'll approve you early? No. Does it mean that you get in front of a judge? Most judges are going to look at it and say, there's enough here. I think there probably is. Let's see, did I miss somebody here? I did miss a few here. Sorry about that. Let's go back up to Mikey's retired. Good evening. Another VA question. 100% VA, SSDI for 1.5 years. Will be expected to be evaluated for SSDI. I will not be getting any reevaluations to VA. There's no way to really give you an answer to that. I mean, it depends kind of on how old you are. Most people over 50 are not going to find a review. Being 100% VA does not insulate you from a review. It's really just how they coded it. And if you have a serious problem that is not likely to get better, then there's a pretty good chance you will not be reviewed. So I think a lot of it depends on your age and the nature of your impairment. If it's a severe back problem and there's no surgery in the cards, you're probably not going to get reviewed. If it's, a back problem, they know you're going to have surgery, they may say, let's see what happens in 2 years after the surgery. So it's just going to depend. But the older you are, the less likely you'll get it. I was just approved 6 months ago. I had to stop working part-time due to health. I got a letter saying they're sending my case to DDS. I did not use my trial work period. I'm confused as to why. Again, the standard is there medical improvement? Is there medical improvement? And so if Social Security requested medical records and there was some indication that you had stopped treatment or that there's medical improvement, they may want to look further. Realize there is a real push, in Congress to encourage Social Security to cut people off, to get them off benefits. So something obviously triggered a review that they're going to look at it again. Does it mean they're going to cut you off? No. It just means that they're looking at it. So I would certainly continue to go to the doctor so that you have an ongoing record and keep a pain diary if it's a pain case. And you may have to argue it all over again, as crazy as it may sound. But I think you want to be prepared for that, because that would tell me that there's something going on. Is it true that a representative can hide favorable findings that's in their denial letter? I'm not sure what you mean by if you mean by an attorney. No, well, I can only speak to lawyers, and I would suspect the non-attorney reps as well, because anybody representing a claimant in front of Social Security has obligations, and that is all evidence, favorable and unfavorable, must be submitted to Social Security. If you don't, that representative, again, attorney or non-attorney, couldn't be barred from practicing before Social Security. As an attorney, we, in addition to that, have state bar rules that require us to be what they call zealous advocates on behalf of our client. And that means to do everything possible to advance our client's interest, regardless of the impact on fees. So I've had cases, I will tell you, that, I saw an angle to get the case approved early, got it approved early, no past due benefits, no fee. It's the way the cookie crumbles. I asked for a nice review. I've had other situations where Social Security, basically made a decision. We're going to make a decision. We're going to find this person disabled as of, March of 2025, even though our original onset was May of 2023. Call the client up. What do you want to do? Here's the pros and the cons. I don't want to mess with it. I'll take it. Sorry, you don't get paid. That's just the way it goes. So, you take a case in a contingency, and sometimes you don't get paid. But the answer to your question is no. No ethical representative or attorney would ever hide records that would benefit you. It's unethical, and it would get you, it would get you removed from the ability to practice before Social Security. Does it happen? I can't answer that. It does not happen. I don't know anybody. I've never seen it happen. Anybody that I know that would do that. Okay. In my time as a lawyer, what average percentage-wise do you lose an ALJ hearing involving a client with physical impairments requiring claimant to use a walker at all times when walking? Pretty much never. If you have a walker, that's going to eliminate almost every job. Now, theoretically, you could do a sedentary job. So if you were 25 or 30 years old and you had a walker, and that's the only thing that was going on, you had, you didn't have a significant amount of pain, but you had problems with balance and so forth and strength, and used a walker, and you're 25 or 30 years old, arguably Social Security could find you could do sedentary work. If you're over 50, a walker is going to basically limit you to no more than sedentary work. And again, the grid rules are probably going to apply. So I think, if you're over 50, over 55 in particular, the odds of losing the case when you're using a walker and it's medically prescribed, using it at all times, very, very small. Is it possible you get a judge 10%? Yeah, it's possible, but it's pretty unlikely. I would tell you, if somebody reaches out to me and they're telling me that they've got use a walker, in the house, out of the house all the time, and even if they're 40 and over, there's a good chance I would probably take this. For 25, I'm going to look at it a little more carefully, but that's a pretty good sign of a pretty serious problem. And if there's pain associated with it, which is reasonable, that usually would be another factor that would come into play. Okay, Mikey's retired says he was the one who had the VA, and he wanted to know that would he be reviewed, not able to work. And again, anybody who's applying for disability says they not able to work, and I take you at your word for it. I'm just saying that, if you say to Social Security, hey, I can't work, they're going to say, well, join the crowd. Nobody can work. That's what the point of disability is. Again, I think the issue here is there's something that made them think there's been medical improvement. What that is, I don't know. There could be, I'll give you a couple of possibilities. It could be that they see in the record that there's a gap of treatment. You stop going to the doctor. There is a doctor who made some comment about drug-seeking behavior or secondary gain, that you're trying to get pain medications, things like that. I've seen it happen, rarely, but I've seen it happen, where a nosy neighbor or former spouse or somebody who doesn't like you writes a letter to Social Security and says, hey, Mikey is faking it. You need to do an investigation. Any number of things could be. They're not supposed to look at your social media, but let's say that for some reason somebody looks at your social media profile and they see pictures on it from 6 years ago where you're climbing on a ropes course or something. Any number of reasons could be, but something obviously has triggered them to look at it. And I think what you have to do is be prepared to defend yourself. You need to be prepared to show that the medical still shows you're not able to do anything. And again, pain diary, anything you can do to show that you're legitimately not able to work. It's got to be more than just you saying that, though. All right, Jen, our paralegal from Lincoln, Nebraska. How are you doing, Jen? Jen and I talked we actually did a video call today. We have a new call screener, Angela, and so we all did a video call today and had a nice chat. Maureen says, I've received SSDI for about 1.5 years, have several medical issues which made me qualify with that issue, but I work under SGA, received a letter from SA asking for pay stubs. Again, Maureen, this is just one of these things where when they see ongoing earnings, the question is, A, are the earnings that are being reported, accurate? Is this all you're really doing? If SGA is 1,620 and you're earning 1,600, let's say, they may conclude that you are suppressing your income. So, this is one of these things where there's a real push to get people off. And so anything they can look at to say, well, hey, Maureen is really not as disabled as she's not totally disabled. She's working part-time enough where, she put a little more effort in, another half day, every week, then she would be over SGA. So again, doesn't mean they're going to cut you off, but it just means that they want to see your pay stubs. And so you should have, all those pay stubs. I would put it on a spreadsheet, make sure you get it back to them. And just basically your argument is that the work you're doing part-time is the most that you can do. There's really no more you couldn't do anymore, but you're doing it because you have to eat. And again, I always tell my clients, if SGA is 1,620, keep your earnings 1,400, 1,300. You don't want to go too much over that, because if you get over that, it starts to look like you're controlling how much you're getting. And you don't want them to think that. Okay, glutenless Sin City. I'm 100% VA, just my second hearing. Any idea how long it will be? Normally after a hearing, it's 4 to 6 weeks to get a decision. That is normally what you get. All right. So, okay. So this guy put it on the website. So if you want to fill out our survey, go to ssdanswers.com/survey, ssdanswers.com/survey. That is helpful. Thank you, Nose Guy. I appreciate it. Maureen says, I had not sent them because I was unaware I had to. I'm 66, received SSDI for the past 1.5 years. You're getting close to retirement age. Again, I would still send it in. By the time if they're going to make a decision, they want to try to cut you off, you'll be at retirement age. It won't make a difference anyway. But I'd go ahead and get it in. I don't think there's any harm in doing that. Slipcat. I applied 18 months ago, was denied. I made a work attempt of 18 months, but it didn't work. I'm applying again. What are the chances I get the same judge that denied me? Pretty good chance. They typically go back to the same judge. Unless that judge is retired or moved on, it'll go back to the same judge, unfortunately. If you got a low-paid judge, that's not good. Hey, Afsana, I saw your email because I had sent you one. I think you said I got stuck in your spam. So I know I was pretty tied up. I had 5 hearings this week. So I think Jen responded to you, but I'll take a look at it tomorrow. So I hope all is well with you. Would your payments disrupted? No, I think if you send it in, you should be okay. I don't think they would stop you for that. They usually have to give you due process. They have to tell you, but I think that, if you send it in, you should be good. Okay. All right. So again, this is the same question. Amory says, not disclose medical evidence in denial letter. No medical. Now, if an attorney or you submit evidence and it doesn't get in the file because it gets lost by Social Security, that's a different question. Can they lose stuff? Yeah. One of the things I do as an attorney is we're able to access your electronic folder directly. And so I literally upload medical records directly into your file, your Social Security file, so it doesn't get lost. If you're trying to do it on your own, many times you're going to be faxing it to some fax number with a barcode and hoping it gets associated. Sometimes it does, sometimes it doesn't. But if you're asking whether the Social Security adjudicator can fail to put things in there, not, I guess they could. It's not very common, but if it's there, the reason they wouldn't do it most of the time would be it got lost, as opposed to they're intentionally doing it. So this live shows on shorts. Okay, I did not know that because I just set it up to work on the regular live under YouTube. So I was not aware that it was showing up under shorts, but that's interesting because it should be under live. That's the way I set it up. So I don't know. Maybe somebody, Jen, if Noroska, if you want to take a look at the YouTube channel and see where the live is going to, is it going into the shorts? Is it going under live? Let me know. Just text me. That would be helpful. Let me just open my text thing. Okay. All right. Some mornings have been over a month. It may take a while. They may take a while for them to look at it. Rebecca Sanders, I qualified for a brain tumor. I'm up for my first CDR. Last MRI showed permanent brain damage from the surgery. Do I send that information? I would send it in. There's no reason, you meant to send it in a couple of times, but get that information in. No reason to wait on it. Absolutely no reason to wait on it at all. Get that information in. You have to be kind of your own advocate in this. And if you have a barcode, make sure that's there, but you may have to send it in a couple of times, but yeah, get that in. Absolutely. Can an SSA represent no medical evidence found in this file? That makes no sense to me. I mean, especially if you went to a CE. So I don't know. It sounds like this is the representative you're talking about is a Social Security employee. That makes no sense to me. So if you are being told by a Social Security representative, employee of Social Security, that there's no evidence in your file, nothing, and they sent you to their doctors, that's technically impossible. So I would probably tell you, this is where you now reach out. If you don't have an attorney, reach out to your U.S. Senator, ask for a congressional inquiry and tell that senator's office the same thing you just told me, is that, you have, there's a lot of evidence in the file, but they're telling you it's none, and we need an answer for it. And they'll, as you saw from somebody earlier, that they'll get an answer from the Social Security Administration about the status of your case. Laura says, I've called DDS every 3 weeks to make sure they don't need more paperwork. Now they're telling me they can call my analyst. He gave me his number. This is my initial app. I'm told it's best to call. It's unusual. Well, the analyst, you mean the adjudicator? Yeah, that's good luck getting a hold of them. But theoretically, you could call the adjudicator and say, look, I want to give you everything you need to make a decision. What are you missing? And I've done that many times with adjudicators. Sometimes I can't. I leave message after message, never get through. Sometimes I get through the first time. And I'll say, what do you need? Well, I've got everything I need. Well, would an MRI help? Sure, send an MRI. Sometimes they'll tell you, we don't have any information from Dr. Smith. He never responded to us. So I'll call my client. Dr. Smith is not responding. Can we get those records? And we upload them. So it can be an interactive process with the adjudicators. It's less than it used to be. Years ago, there was sort of an ongoing dialogue between attorneys and adjudicators. Now you call them and they don't call back. So it's kind of hard to do that. Sandra, thank you for my case. My pleasure. RN for 35 years. Obviously, that's a great work history, 5 back surgeries plus a spinal cord stem. Also secondary long COVID. How are judges responding to the diagnosis? Long COVID is interesting because I'm seeing more and more of those. They typically, Social Security is being a little more open to long COVID arguments if it's respiratory or cardiac. Other, fatigue and so forth, not so much, but respiratory and cardiac. The 5 back surgeries and the spinal cord stem is objective evidence. That's going to be the strongest argument we're going to have, I think. But the long COVID is a secondary type of thing, and it just makes things worse. But you've got a great work history, 35 years as a nurse. And again, these surgeries, obviously, you probably have failed back or, post-laminectomy syndrome. And, that, as I mentioned before, I had a judge basically recognize that is not, not something that is going to allow you to work. Happy birthday in advance. Thank you very much. Let me take a survey. How old do you think I am? How old does everybody think I am? Put it in the notes. I'm just curious as to what you guys think. Whether you think I'm older or I'm younger. I'm curious to see who gets it or how close we are. Laura says, I have an upcoming appointment with SSA psychiatrist. What should I expect? I think that, normally these appointments, they're going to do a number of tests. And I don't necessarily, you don't necessarily want to prepare for these things because they're going to ask you for a history, and they'll give you their certain tests they give you, like they'll ask you, to spell a word backwards and forwards. They may ask you, the last certain number of presidents. I don't want to say much more than that because if you know what they're going to ask you, then you'll have the answer, and that may not be a realistic idea of what your condition is. You want to do the best you can. I mean, they also have questions that will basically tell them if they think that you're malingering. So I would just say go in, give a clear history. When they ask you about what you've been through, don't exaggerate. Don't don't basically say that I can't do anything at all. I'm completely helpless. But be very direct and clear about what you've been through psychologically, and answer the questions as best you can. And you'll see how it turns out. But I don't want to tell you the questions. I mean, I've seen enough I can tell you, but what's the point? Because again, if you know the questions, you'll answer them, and the report will come back that you have minimal limitations when it's because you have the answers to the questions. So, I don't want to do that. Maureen says, happy birthday. Thank you very much. Thank you very much. I appreciate it. Denise, my hearing's finally come up on July 10th. My attorney sadly died. About a month ago. Thankful to have another attorney. He has about 200 hearings a year. He can resume the case without delay. One comment, because I had this happen to me a couple of years ago. I picked up a case where the attorney had died. And the issue I ran into was this attorney was a solo practitioner. He had nobody designated to be his successor. And so there's no way for that dead attorney to withdraw and waive fees. I had to file a fee petition. So if your attorney died, I would tell your new attorney to reach out to the office of the prior attorney and find out if there was somebody who could execute a form 1696 sup 2 to withdraw and waive fees. Otherwise, your new attorney is going to have to file a fee petition, which nobody wants to do, and save him the trouble. So I would tell you to do that. Happy birthday, says Corlil. You were very well. Thank you. I appreciate it. I appreciate it very much. You already know what I'm going to ask. If a bill passes the Senate and the House on Medicaid, what happens to adult people on disability? Thanks. I appreciate it. We don't know yet. I don't want to. I know that in Georgia here, Georgia is moving quickly to try to grab as much Medicaid money as possible. I think, there's going to be a lot of negotiations. Why don't we table that until we have a final signed bill? Because we just don't know enough. And in fact, what we'll do is we'll find somebody who can comment intelligently about what that means for Medicaid, Medicare, things like that. And it's not me. That's just not, I'm focused on getting people on disability, not on Medicaid, Medicare, things like that. But I want to table that discussion until we have a final, final bill. Sean, Hannah, so much misinformation off this new bill. Do you have any idea how it may affect people? I have not seen anything about SSDI, but again, this is just me personally. I don't like to focus on unpassed legislation, especially a huge bill, because there's just things that get changed at the last minute. And let's just wait until it passes, if it does pass. And there will be, reams of paper of analysis of it. It'll be, there'll just be a lot more information out there that's accurate than what we have right now. We just have what if, and I just don't feel it's worth my energy to play what if games, because we just don't know. And it may not pass at all, and they may come back in completely different form. So we don't know. So let's just wait and see what happens. And once we know, then if I can't get you an answer, I'll get somebody on who can give you an answer. Sharon, hey. AI says my attorney cannot by contacting the payment center, a person able to contact the payment center, so AI, your office is able to. Well, in theory, yes. The problem is, and Stephanie in my office has been calling on your behalf. The problem is you can't get through. They won't answer, they won't call back. They don't pick up the phone. So that's the big issue. That's the big issue. But we are, we will keep working on it. We're going to get you paid. We will keep working on it because we want to make sure that you do get paid. That is unacceptable if they have not paid you yet. Let's see here. Okay. Vincent Costanzo received an email today saying your submission status has been updated. I logged in, nothing was updated in my claim status. Still at step 3 under my appeal. Weird. Yeah, that is kind of weird. And again, I just don't put a lot of faith into the step 3, step 2 nonsense because it doesn't really mean anything. Sam the man. Asked you last week about Gen X. My hearing was next Tuesday. The attorney has not reached out to you. That's not good. Watching all your videos, any of the suggestions. Watch my videos. I mean, I think that's a good way to do it. There may be others folks out there. I'm not sure if Walter has any on hearing. I know there's some other attorneys who've got videos. There may be even like a sample hearing out there. Somebody I think did that one time. I think the main thing I would tell you is focus on the specific reasons why you're not able to work. You want to have answers to, your past work, what you did, how much you lifted, carried, walked, all the activities there. And you want to be able to answer the judge or your attorney if the judge says, I always ask this question, how long can you stand? If you're in Department of Motor Vehicles or in a movie line, how long can you stand? And it's not very long. It's 10 minutes, 15 minutes. How far, how long can you walk? 15 minutes, 75 feet. How long can you sit in an office type of chair? And it's not one day if you had a gun to your head. It's ongoing, day after day after day. So when I say how long can you sit, I'm not saying on one day if you had a gun to your head. I'm saying think about this. How long could you sit if you had to do it 8 months? For every day for 8 months, every work day for 8 months. So you want to have answers to all those questions: crouching, crawling, kneeling, stooping, things like that. Heat and cold. Again, I've got a bunch of videos about all this type of stuff, but you want to be able to give very specific information to these things. And again, your attorney should really be talking to you. What can I tell you? You should be, calling up and finding out what's going on because that's not good. How do I ask about medical aids, such a cane or as a walker? Well, there are a couple ways to do it. One is to go to your doctor and say, look, I'm having a lot of trouble walking, not balanced well. Can you prescribe a cane? And see if the doctor will do it. Or go to the drugstore and buy a cane or buy a walker and tell your doctor, write the doctor a letter saying, I got this because I needed it. I wanted you to know, please put in the record, this is a reasonable thing for me to do. Kind of the same thing. That's what I would do. But if you need it, and if the doctor won't cooperate with you, but you get it anyway, make sure you write down the date you got it and, send the doctor a letter saying, I got this because I really need the balance support. I can't really walk without it. You got to, again, be aggressive about that. Denicia Rose just received an unfavorable decision, 16 years, severe scoliosis, 60-degree scoliosis with twist. Lawyer was no show at hearing. And you went solo. Judge says 33% curve, not a single doc. Said 33 and diagnosed with POTS. I think what I would do is, I would have somebody look at that for possible appeal. That is unbelievable that your attorney was a no-show. What is the excuse for that? That doesn't make any sense at all. But I would reach out to, an appellate lawyer. At the very least, what your attorney needs to do, it was a no-show, get you a copy of the audio of the hearing, get you a copy of the exhibit list and get that to an appellate lawyer. And there are plenty of people out there who do it. If you email me, I'll give you the names of some attorneys who do nothing but appellate work. But you're going to need to get the record, and you're going to need to get the hearing recording. But that is a pretty bad sign that your attorney didn't show up. That's not supposed to happen. Okay. Darren, I have 1 year's vacation, can draw waiting for my, yes, you can draw from that. That does not count as work. It's not allowing me to take the survey. Well, let's go to it, ssa.gov. I'm sorry, ssdanswers.com/survey. And I'm looking at it right now. So I'll put this in the notes here. I'm looking at it right. So it is working. Let me also put this on the banner here. But I appreciate you doing it. Oops. Okay, that's what I just copied the link. So that is the survey right there, and it's just some questions that we're trying to use to do better, really, for our clients, to get more information that we want, that they want, or the people that are on our live streams want. If you don't ask, you don't know. I don't want to guess, so I'd rather know. Okay. But Denise, I think that you want to look into an appeal. Now, if you agreed to go forward with a hearing without an attorney, I don't think you can appeal on that basis. But if the judge represented something that was 33% when in fact it's 60, that seems pretty material to me. But again, I'd want to listen to the audio. I'd want to listen to or look at the record. And again, you want to have an appeals person do that. Okay. Saint PR. I applied at 39, got denied. Judge had 3 jobs you could do. The vocational witness said 3 jobs. I have problems with my back. MRI shows stenosis, disc bulge. I'm 44 now with an MRI on my neck with radiculopathy. Chances would be better. Honestly, Saint, the difference between 44 and 39 is not relevant for Social Security. You're still a younger individual. It sounds like maybe your back got worse, but to win at 44, you're going to need something from a treating doctor, ideally an orthopedist or neurosurgeon, that says that your level of pain, loss of function is such that you could not do anything at all. It is really hard to win at 44. Really, really hard to win. And it's really hard to win under 50. So, whether the new MRI is enough, I can't say, but I think it would really help to have a doctor fill out a functional capacity form. What is the difference between a representative and an attorney for disability during reconsideration? Well, it's not about just reconsideration. So Social Security is kind of unique in that you can practice before Social Security without being an attorney. You can be a designated representative. You could be, a parent or a guardian or a brother or sister, a good friend, and represent somebody in Social Security. Now, the attorneys obviously are people like me who've been to law school. There are some non-attorney reps. I think it's called the EPNA certification, EPD. I don't know what the name of it is, but basically these are non-attorney reps who do this, and they've gone through some training. And again, like with attorneys, you're going to get some good, some not so good. Obviously I'm biased a little bit towards attorneys because I think that, you've gone, as an attorney, you've gone to law school, you have ethical obligations above and beyond what Social Security requires. But there are some very, very capable, and I know some of them, non-attorney reps. Now, when you get to, a good friend or your Uncle Larry, or your cousin Ronnie, that's where I would draw the line. I wouldn't go there. So anybody can be a rep, but as an attorney, I went to law school, passed the bar. I've got a license to practice law in federal courts, whereas other non-attorney reps or non-attorney or none or just regular people don't have that. It doesn't make me better or worse than anybody else. It just means that I've gone through a certain amount of training. Honestly, the bigger thing for me is I've done this for 35 years. So, and I teach it. I've done it for 35 years. So, there are probably people I know, like guys like Brian Konoski or Adriana De La Torre, who know a lot more about some of the appeals side of it than me. But, you get pretty good at what you do by doing a lot of it. So what I'm really offering to my clients is just that 35 years of experience. If you had a non-attorney rep with 15 or 20 years experience and they learn from their experiences, you may get a good result. It's just a matter of you have to feel comfortable when you talk to whomever you choose, you feel comfortable that they understand what you're going through and have a path forward. I'm a big believer in, as you probably know, having a narrative when you talk about what your journey has been from being able to work to not able to work, and you want to have a theory of disability, the listings, the grid rules, functional capacity, and be able to wrap it all together. And that's really what I think what you want to be doing. Okay, so I know Amory's is asking a number of different things here about a CDR claim that said that the favorable things are not on the denial letter. Again, I would then appeal. I think you need to appeal it, but you might want to have somebody take a look at that, an attorney take a look at it, or if in fact there were things that were in the record that were not there, your U.S. Senator's office can maybe get some answers for you. But it sounds like you got denied, and so you need to appeal it within the 60 days, and then keep fighting on that basis. Windabush got denied 2 year now. My appeal has been 15 months. Again, Winda, I would tell you, you want to go ahead and contact your senator, representative. That is, 15 months is too long. And I think that's what you want to make sure you get a congressional inquiry at this point. Maureen says, thank you very much. KR, I can have a review, even though I just approved 6 months ago, even not all the doctors. Yeah, I think we had talked about this before. They can review you whenever they want. And obviously something has triggered them to do it. Denicia, all daughter's doctors said disabled, missed for 45 days of school to pain, but maintained 4.0 GPA with high honors. Judge says pain is subjective. Pain is subjective. Again, this is obviously a younger person, I think, so I'm getting a picture here with bad scoliosis. Interesting, I had a case, this is going back 15, maybe 20 years, a young woman who was in college here in Atlanta, and this is when the hearings were all done locally, and she had really, really bad scoliosis, but she was in college, which is SGA, substantial gainful activity, going to school. But she had to have special allowances to give her extra time to get to classes, and she had to have her mother would go with her to classes and take her places, and she'd have people taking notes for her, things like that. And so, she was able to go through school, and the judge was okay with the fact that she was getting all this special help and decided that the schooling she was going through was not SGA. Your daughter has missed 45 days of school, but maintained a 4.0. Obviously, she's really, really smart. The judge obviously felt like, that the pain that she's in, it's too subjective, but, how do you explain 45 days missed? Again, it's a younger person, hard to win for a younger person, but, certainly have somebody to take a look at it. Tara Upshaw, how are you doing? One of my clients we got approved on recently. Good to see you, Tara. How are you doing? Miracle after miracle. Hello, Joe. I guess that's for me. The Dreamers Club. I got before an ALJ, or go before an ALJ on August 1 at 54, turned 55 a month after the hearing. Will the ALJ again use the next grid up? Probably not, since it hasn't happened yet. The real danger is if you had turned 55 in July, then that might happen. But I think it hadn't happened yet, so you're still going to try to argue the sedentary grids if you're claiming the grid rules, from 50 to 55. But I think they're not going to, say we're going to hold it open and approve it. I've never had that happen, at least. Sheeran. Okay, so I know that we talked about this before. We're going to, I know Stephanie's working on it. Just got Stephanie a new computer, so she'll be even more capable of getting stuff done. Hello, Robert. Is it true that federal law enforcement officers switch from SSDI to regular Social Security at 62? I don't know that. It's possible, but I had not heard that. So that is beyond what I know. Cushing syndrome. So obviously that is an endocrine issue. You don't win by diagnosis. You win based on the effect that that diagnosis has on your capacity to work. So, that's what I would tell you. Let me actually put this on the, let's see here. Let's put this. Okay, I'm kind of messing with my my little crawls here. So let's do this. Let me go back to the comments. I'm trying to do 3 things at once, so that's why I'm kind of getting a little finished here. Okay. Okay, RD is 56, just had my 6th surgery, bladder surgeries, no rotator cuff, can't work anymore, 38 here, hairstyles. Again, 56, multiple surgeries, that looks pretty decent. Looks pretty decent to me. I think that's a pretty good argument. Robert says spinal, epidural. I'm not familiar with that term. Let's see what it is. Spinal, epidural. I'm not spinal SEL, excessive buildup of fat tissue in the epidural spaces of the spine, potentially compressing the spinal cord nerve, leading to neurological deficits. So basically excess fat in the spinal cord area. So I think it's going to depend on severity. Is it causing pressure on your spinal cord? Are you getting numbness and tingling, loss of function? So again, you don't win on the diagnosis, you win based on the effect that it has on your functioning. Randy, trying to advocate herself being a pest. We filed for recon in April, but we've seen no movement at all. Well, we are now in July, so April, May, June, July, it's 4 months. Recon typically is going to be about 8 or 9 months. So, it's not being a pest to ask because it's a legitimate question, but 4 months in this climate is quick. So I would tell you that we're probably not going to hear for another 3 or 4 months. And I think, if I'm not remembering where you live, Randy, are you in Texas? I don't remember. Let's take a look. Because some states are a lot worse than others. You were in Alabama. Okay, so Alabama's not quite as bad. So I think that, we'll probably be in the lower end, the shorter end, but I'm still thinking probably September, August, September, something like that. But it's not, 4 months is not that long for reconsideration, unfortunately. Again, Emery, I hear you, and I think that obviously something is not right. Something is not right. Oh, so people are saying how old. All right, so Sandra thinks I'm 55. Robert thinks I'm 59. Tom, you're going to be banished, think I'm 72. Let's see. Blue City, called my office on Friday, left a message, called again today, left a message. Well, I will tell you, as I said, I was pretty tied up. So normally, and which we are, I'm not making excuses. I'm just telling you, we're training a new person because Madeline, who has been with me for a while, probably will come back, but she's out for the summer. So we have a new person who's being trained. I was out of pocket. So things are slowed down a little bit, but I'll make sure we're, we will, normally Jen's pretty good about getting back to rehab pretty quickly. All right, Maureen thinks 62. All right, Blue City thinks 55. Lily thinks 55. RD, am I 62? Am I 59? Okay. Joni, okay. Joni, we had Joni's case today. I think we're going to win. So hopefully it was a good thing. But you did a good job, and I think it was a good case. Second anniversary of my 26th birthday. There we go. I like that. 50. What you're saying is I'm 52. Okay, that's what you think. All right. I have a mix of mental and physical illnesses. I have emphysema, stage 3, is recently put on oxygen. Will be being put on oxygen help your case? Absolutely will help your case. That's almost listing level. So I think that will. Okay, happy birthday, says RD. Marie says, I'm 25. You were really close, really, really close. Not quite. Alex Ortiz, thank you for your video. Stopped working and submitted my case 124. It's denied initial recon hearing 525 approved 625, 42 years old from Puerto Rico. Great. That's awesome. That is great. That is great. You will be 66 next week. No, you're close, but no 66. Happy birthday, Trish, Sean. Can't get my medical records from the hospital. Treated. That's going to be a problem. That is correct. And you said I'm 72, so I'm not going to tell. No, yeah, that's a problem. Many times other records will describe the records, so it may be impossible to get them. David says, happy birthday. Thank you. 62. Thank you for that. No. Happy birthday, says T-Lux. What to do if your disability check amount was calculated wrong? That is a good question. And I think the best answer I can give you, because, honestly, as an attorney, there's not a lot I can do about that. That's where I tell people, contact your U.S. senator, contact your representative. That's really what they can help you with. And the Braves still suck. You know what, Shub? I'm not going to argue with you there. The Braves are a disappointment. You're from St. Louis, I think. You're a St. Louis fan. They'll show flashes where they look like they're halfway decent, and then they get shut out yesterday. They waste a great effort by Spencer Strider, their best pitcher. I just think, what seems to have happened is that some of their, bangers, some of their guys like Acuna and Albies, it just seems like they're a step slow. I don't know. I think they lost some good clubhouse guys. Dansby Swanson, they let him go a couple of years ago. Good clubhouse guy, Freddie Freeman. There's some intangibles that seem to be missing with the Braves. I don't really know. But we have a really good GM, this guy, Alex Anthropoulos, and he's always making trades. So, they're still competitive, but I suspect this year may be a write-off. But I think we'll be back next year or two. But, it's disconcerting a little bit. Now, the Falcons the Hawks made some interesting moves. Talk about that first. They picked up a couple of really good players. They've been mired in mediocrity for many, many years, but they seem to be trying to make a little bit of a splash. Not sure why they have such trouble landing free agents. They're talking about maybe getting Giannis, which would be really amazing for Milwaukee. But we'll see. And then the Falcons, they've picked some players up. They've never had a pass rush for years. So, you just hope that some of these teams, that you follow will be making some strides. At least they'll put an entertaining product in the field. But the Braves, yeah. Okay, Mr. P, can I ask for dire need other than financial and terminal illness? I think there are like 5 reasons you can ask for dire need. In fact, I just did a video about this that my son just finished editing. I don't remember what the 5 things were, but it's got to be something like you're living in your car, you can't afford medical care, you're about to be homeless. But dire need just doesn't seem to work that much anymore. It's really, everybody's using it. So I think really, I find it's a better thing to do is to contact your U.S. senator and say, I need a congressional inquiry. That's what I think is a better thing to do. Okay. How does working from home as an accommodation from a previous employer look to SSA? Well, an accommodation is not SGA. So if you're getting a special accommodation of working at home when nobody else is, that's an accommodated workspace, and that is not SGA. So, it's an interesting point because more and more people are working at home. I work at home for the most part. This is my home office. You can see behind me here. I blurred it out, but it's my home office. Um, so whether Social Security will change their procedure to basically say, well, people that are working at home, that's the same thing as SGO for work, maybe, but right now it is an accommodation. So if you got a special accommodation to work at home, just like if you got a special accommodation to come in late or to use the bathroom 3 times an hour, that is not competitive work. That is not SGA level work. Although, again, if you're making the money, it's more of a problem. But I think it's certainly not something that other employers would be likely expected to do. Around my way, people were actually back feeding electric service with the Tesla Cyberbeast when the power went out. Okay, I'm not sure what that's all about, but I know we did have last Thursday, we had a big storm. It was hailing, it was just torrential rains, and power was out for like 5 or 6 hours. My wife wants to get one of those generators from Costco. My next door neighbor has one. It's gas powered. So we'll see, because, when it's in the summertime and the power goes out, it's pretty hot. So we'll see if we do. I don't know. Any knowledge of what the big, beautiful bill does for veterans? Again, I'm going to hold off on that. I don't know. I'll be 59. It says rock driller in October, applied for SSD after a fall in December of 22, turned down in March. My attorney, OBD Osterhout-Berger, very good lawyers, have refiled. They probably have appealed it, I'm guessing. What can I expect? I'm lost. My retirement is running low. They can't speed it up. I mean, again, you can ask for a congressional inquiry. Look, I do a lot of work with Osterhout-Berger. They're very good lawyers there, very knowledgeable. Lindsay is a good friend of mine, Lindsay Osterhout. Carl's a good friend of mine. They're all very, very good. So you're in great hands. It's just the system is the system. So, they'll do everything they can to get you ready for an approval, but they can't speed it up. I can't speed it up. It's just, what are you going to do? Jeff says 64 years young. You are correct. I will be 64 years old next week. It is hard to believe. I will tell you, I don't feel that old. And when I was growing up, you hear the Beatles song, "When I'm 64," everybody was like, that's really old. And now here I am looking at it. But the good news is my mom made it to 101. So theoretically, if genetics are any guide here, I've got another, 36 years to go. And you got to work out. You got to be healthy. I mean, I played tennis several times a week. That's why I started this late. I had a tennis match, and I just wanted to get my 2 hours in. I walk my dog 4 hours, for 4 miles a day, when I'm not playing tennis, work out. So age is just a number. They say, 60 is the new 40. So, I look at it like, I feel as energetic and strong as I ever have. I don't think there's any, if anything, I know a lot more than I used to know. And, like when I'm playing tennis, I maybe lost a step or two, but I know more about what I'm supposed to be doing. So I really haven't noticed a big difference, but yeah, it's hard to believe. But all those people thought I was in my 50s. Thank you very much. I'm fortunate. I genetically, I got a good head of hair. I don't color it. So it's, the gray is the gray, but at least I got hair. A lot of my friends don't. And just, keep on keeping on, working out. I read, you got to keep your brain active. I read constantly. I'm learning, about all this AI stuff, learning new things all the time. Again, since I'm talking about it, I'll just tell you, I don't watch TV. I stay away from TV. I think TV is mindless. I think it doesn't trigger your synapses. I think reading is much better. Doing things, whether it's puzzles, the jumble, crossword puzzles, learning. I'm learning, like I said, AI. I do not watch TV at all. My wife has it on at night. Before sleep, she'll want to watch House Hunters. I'll watch a football game every once in a while. But if I didn't have a TV in my house, it would not bother me at all. My opinion, and I will tell you, my granddaughter, I got a almost 2-year-old granddaughter, she loves watching videos. And when I'm watching her watch the videos, she's just got this stare on her face. And it's just because it's not triggering your mind. It's just you're basically absorbing information. You're basically passively watching, but you're not actively involved. When you're reading, you're thinking about it. You pick a picture in your mind about what this character looked like, or it may trigger a memory of some type, or you'll talk about it afterwards. If you're learning a computer program, or you're learning how to do this, or you're writing. I do a lot of writing, for blog posts or videos. You're thinking. So again, my recipe for a long life and healthy life is, a lot of exercise, try to eat well, and keep your mind active, but stay away from TV. Personally, that's just my thing. So anyway, not that anybody asked, but that's what I'm telling you, since now you know how I'm my ancient age here. Can missing medical records be grounds for an appeal? It's told to stop sending in records. We don't duplicate records when exhibits in the hearing decision. Yes, there is some law that says that if evidence was available but not in the record, and its material would have made a difference, that can be grounds for appeal. The issue is, why did it get in there? And if you have written documentation that they told you to stop sending it in, and it's relevant, I think that would be really strong grounds for appeal. I think that if it was there, and even if you did an affidavit or a Form 795 and you said they told me to stop sending it in, that could be grounds for appeal. But if it existed, it's material, and it's not there, and it would have possibly made a difference, that very well could be grounds for appeal. I would talk to an appellate attorney about that. Again, I do a lot of work with Osterhout-Berger. That's one of them. There are others. I'm happy to give you some names, but I would definitely look into that. So yes, possible. You are welcome. RB says, thanks, happy birthday. 67. Alicia, I'm not 67. I'm 64. So we're going to be 64, but you're close. I won't hold it against you. I know you're stressed because you got a hearing coming up. And I've been working, actually, I was working on your file today. And you agree with your wrist. Yes, but we will get you, I've been doing some interesting things in your case. You have a very interesting case. And as I sent you that email with the whole date less insured issue, but I know we have some things around that, but I was working on the brief today and kind of talking about that, because obviously I want to get it in tomorrow, but I think we'll be pretty much ready to go, and we'll talk tomorrow. Karen, I had a physical C and said SSA never sent my medical, never asked me why I can't work. I use a walker. Must felt the CE gait test. Yeah, what I would do there is I would write out all the things that happened at your CE, everything the doctor told. Excuse me. Sorry about that. Again, I played 2 hours of tennis in the heat, so I'm a little tired there. I would write down everything the doctor told you about, not what he didn't have, what he didn't ask you, didn't mention the walker. I would write all that down. And then if you get to a hearing, your attorney can, certainly ask the judge to give that consultative evaluation less weight if it does not help you. If it helps you, then obviously don't do that. But if it does not help you, you can argue there. CDR with mental health, new diagnosis of POTS. Yes, the new stuff is certainly relevant, because again, they're trying to figure out, are you still disabled? You're not limited to only talking about the things that got you disabled in the first part. So anything new like POTS, which is where the blood doesn't get to your brain and you tend to fall over and things like that, that would be relevant. So yes, you want to do that. Have an amazing, enjoy the 4th and 64th, and have a glass. I don't drink, honestly, I very rarely drink. It's just, I don't have a problem with it. I just, every once in a while I'll get a glass of wine. Just never had the interest in it. Just doesn't do anything for me. I know people that like a cocktail every once in a while. Maybe once a year if I'm at a wedding or something like that, I'll have a 7 and 7. But I don't like beer. Wine I can take or leave. That's me. But I don't think it's any harm for it. It's not me. Okay. Think you look okay. I look younger than my videos a few years back. Staying fit is key, man. You're gonna have to wait. Yes, you're right. And I definitely have lost some weight since then. I think that I obviously could lose more, but I mean, you can't really exercise your way to losing weight. It's just, it's hard. I like food, but I think the key thing is, for me at least, put it on a plate and don't graze. I have a habit of grazing. So I think you put it in the plate and just eat what's there and let your body catch up to your brain so that you don't eat when you're not hungry. I think that's important too. And I think as I've gotten older, I don't feel as hungry. So maybe that's part of it too. NYU medical records, since the records digitally, if the analyst says you receive the records, can I make sure they got what they're supposed to and all? Again, as an attorney, I can log in and see, but you can certainly ask them what they've got. You can ask them what they've got, and hopefully they will tell you. My hospital swap portal sites. Most information I've been transferred to the new portal. I can access expensive records. Yeah, that could be a problem. I mean, the portals are a great way to get records, but if they change them up and it goes from this company to that company, that can be an issue. And now there are typically records that the hospital maintains, but to get those, you may have to pay for them, or better yet, let Social Security pay for them. So if there are records that are existing, let your adjudicator know to get those records directly from the hospital, not through the portal, or use the HIT system, the Health Information Technology System, to get them. So you can probably still but let the adjudicator do the work. Let them do the work. You don't need to do it. Would a work from home call center job as an escalation supervisor be considered transferable skills? The whole job is scripted, two weeks to train. Will they ask me details like this? I don't know. Again, if you're a supervisor, that may be considered semi-skilled, but 2 weeks of training suggests more of an unskilled kind of job. Those jobs, if it's work from home, there may be some transferable skills, not a lot, because it would not necessarily be to another. Probably not a lot of work at home jobs that you could transfer to. But yes, that could be possibly a transferable skill. It very well could be. That's something that a vocational witness would look at and say, the job is inherently a work at home job. You're an escalation supervisor. That, supervisor probably weren't supervising other people. But I would emphasize the 2 weeks training, which again sounds like it's unskilled. So it may be a semi-skilled job inherently, but it's probably not any transferable skills. I can't say for certain, but I'm not a VE, but I think that's probably pretty unlikely there's any transferable skills from a job that you've got 2 weeks of training on. Generally, to be a semi-skilled job, 2 or 3 months of training, not 2 weeks. I said, have a glass for me. You can have a glass of Cook for me. Don't understand. I'm not sure if I understand what you're getting at, but it's funny for you. Maybe you could explain. Maybe explain what that means. Okay, Cards ain't going nowhere either. Freeman, it's your favorite. Yeah, the Cardinals have actually always been a good. I always admired that team. They always seem to have good front office management, good culture in the team. But every team is going to have its ups and downs. Obviously, the Dodgers and the Yankees are spending huge sums of money to basically buy championships. But more of the mid-market teams like Atlanta and St. Louis do have a little bit of they're going to have their moments, so that's fine. Freeman, Freddie Freeman was on the Braves for many years, and he left. He's from Los Angeles. He signed a big contract with the Dodgers. I think he wanted to stay here, but there was some issue with what his agent said and told the GM, blah blah blah. But I think he's 36 or 37, so he's getting up there. But talk about just a great clutch hitter. And they won a World Series with him. He's a great player. Definitely a Hall of Famer. And just a really sweet swing. GR Gomez, King G, happy birthday and happy 4th. Yes. Mr. P was denied for SSI to wait for apply for SSDI. Will they use the same info, middle exams? Can I ask a congressman? Yeah, if anything that's in that record, they'll use it. They may send you out for more, but they will use it. That is evidence. Yes, they will use. Absolutely. Falcons 28-3. Now that's not very nice. And what he's getting at is the Falcons were up in the Super Bowl to the Patriots. This is, I don't know how many years ago, maybe 19. I don't remember when it was, but it was a number of years ago. Matt Ryan was still the quarterback, and they were up on the Patriots 28-3 in the fourth quarter, maybe, and they ended up losing. And it is, it's just six in everybody's craw. There was a very famous play where they needed just to get a first down, and all they needed is, and they could have run the clock out, and the running back at the time missed a block. And a lot of people think Kyle Shanahan, who's now the coach of the 49ers, called the wrong play, called a pass play instead of a run play. And Devonta Freeman was the running back, missed a block. They ended up getting, fourth down. They had to punt it, and then Brady came back and won. It's not a great memory. And, those videos come up sometimes of showing that great comeback. But give it to the Patriots and give it to Tom Brady. They really they did it. So it was 28-3. Not a good day for Falcons fans. Not a good day for Falcons fans. Okay. All right. So we are actually, I don't have any more questions here. Wow, that's pretty crazy. Normally I have a lot of questions. I don't have any more here. So let me just check one more place here. No more questions. Okay. I could end early, or I can talk about a couple. Oh, here's somebody get a free case evaluation there. Let me pull this up here. Sorry about that. These are just some notes from some of the videos I've talked about before. And let me just talk about some of this stuff. If there's any more questions that come up, I'll answer those. And if not, we'll close it out in 10 minutes or so. Maybe people are. Okay, Ray says, on SSDI, what can you do to get training or supplement? Not sure if I understand you. What can you do to get training on another job or supplement your income? Basically, and let me just talk about this a little bit. If you are on SSDI, here's some more questions coming in. Okay. If you're on SSDI and you want to try to work, there is something called a trial work period, where in any 5-year period of time, you have 9 trial work period months, and you can earn any amount at all, $10,000 a month. I think the amount to trigger one of those months is like $1,160. I think it's what it is. So in that 9 months, you can earn as much as you want. Doesn't affect your benefits, and theoretically would not trigger a review. Once you've used up that 9 months, you are at risk if you go over SGA, which is $1,620 a month in 2025. So I know it's a lot of confusing tables, but theoretically you could use up your 9 months, then continue to do part-time work at $1,300 or $1,400 a month and not have a problem, still get benefits. But if you go over the SGA, then you are overpaid for that particular month, and you're also going to likely trigger a review. So my point is, you're saying, well, what can you do to get training or supplement? Is you can go to, try a job, go through the training of the job. Theoretically, SGA doesn't require income. If you're doing something 8 hours a day, 5 days a week or whatever, that would be SGA. But generally speaking, they're going to look at the money part of it. So they want to encourage people to try to work. So what I would say is, if you can find something you can do, try it. Try the trial work period. Try to work. You'll be happier. You'll be more fulfilled, and you'll make more money. But just be aware, what you don't want to do is to use up your trial work period months and then sort of be earning $1,700, $1,800 a month where you're over SGA and now you're in an overpay situation. That's what you do not want to do. Or you get a job where you're making just enough to, $2,000 a month, but you're not able to pay your bills. So, if you stayed on SSDI, and let's say you're getting, whatever you're making, $2,500 or $2,000, you're actually better off. So you just got to be careful when you try to work after being approved. RD says, does California have a slow approval process? Yes, it does. It does. It's very, very slow, unfortunately. It's just really busy out there. California's slow. Texas, Florida are the really slow ones. Mr. P, which representatives can you ask? I mean, again, I think, again, I always go for the senator. I think that's more powerful than a representative, personally. Laura Roeder, I was just awarded SSDI. I'm so scared of losing my affordable housing because of the lump sum back pay. Yeah, that's beyond what I can't speak to that. I would wonder whether I'm sure that's an issue that's arisen before, and there may be somebody to talk about that, where you could treat the lump sum as payment over an extended period of time, or maybe you put it in some sort of a trust. I don't know, but you're not the first one who's had to deal with this, I would say, but I don't know the answer. Christina says, thank you. Yes, like, share, subscribe, please. Can you switch from a representative to an attorney in reconsideration where she's not properly represented? You can. Realize that if you change representatives, the prior rep needs to withdraw and waive fees. Otherwise, both people would have to file a fee petition, and nobody wants to do it. I always tell folks, if they call me and say, I'm already representative, whether it's a non-attorney rep or a lawyer, work things out with your representative. Don't switch attorneys if you don't have to. Try to work things out. It's just, you're better off, what is it, the old saying, leave with the one who brung you. Don't it's not going to make that much of a difference, really, unless you're just completely unhappy with the advice you're getting. But you can switch. Many non-attorney reps will waive fees, but I would have that conversation before changing anything. How is close to the information on the SSA website pertaining to the amount they'll say if you were to file? What would you be awarded? Trying to be positive. Well, it's in section D, and I'm not sure if I've sent you that. We can look and see if it's there. Sometimes it is there, and it will tell you approximately what you're going to get, or in your My Social Security statement. It's pretty accurate. It may be off by $10-15, but it's pretty accurate. If the letter from SSA come in an envelope that says Office of Temporary and Disability Assistance, does it indicate anything why the temporary office? I've never seen that. I've never seen temporary. I don't know what that means. I don't know. I'm afraid I can't answer that because I just don't know. Do not forget to press like or thumbs up. Yes, please do. Thumbs up. Like it. That really helps me. These videos people watch them afterwards, and it does help. What we're doing also now is some interesting things with AI. There's a couple of programs out there where you basically take the live stream, and actually I use a program called StreamYard to syndicate this. In other words, what StreamYard does, I log into StreamYard and I connect my Facebook, my YouTube, and my LinkedIn to it, and when I do this live stream, it goes out to all those platforms, Facebook, YouTube, and LinkedIn. It also records this. So that recording, we can download, and then we can take it into one of these AI programs, and it automatically chops it up and creates videos. And it'll create shorts and things like that. So we're doing a lot of exploring with that. It'll also do this, and I've done this too. I'll dump the recording into an AI engine like Notebook LM or ChatGPT, and I've got the paid version of ChatGPT, which is the private version, and it will do a summary. And it's really pretty cool. I mean, the AI stuff is just a game changer. It's really, really cool if you haven't played with it. In fact, I would tell you, if you are, looking at Social Security, and you've got some medical records, find an AI engine. And I would tell you, Notebook LM, the Google product, is pretty good because you can basically tell it to be private, only use what is you give it, and you dump your medical records in there and say, give me a summary. You'd be amazed what comes out. Is it perfect? No, but it's really pretty incredible, pretty incredible summary. And with Chat GPT, what you can do is there's privacy parts of it. The free version's not private, but the paid versions are. And you can ask it, will this qualify me? Do you think this will qualify me for Social Security disability? Is it accurate? It's, maybe, maybe not. That's one of the things we're working on, is maybe where I can kind of take what I know and add to some of these things so that people pose questions and they're getting my thoughts, as opposed to wherever Chat GPT comes from or whatever. So, but it's pretty incredible. It's not going to substitute for, 30 years of experience, but it is interesting, very interesting. Ray Nunya, how worried should we be if it's stopping? It's not going to stop. I think that's a smokescreen. They always throw that out, but it's not going to stop. Now, 10 years, what's going to happen then? I think the uproar would be so great that, these Congress people, they want to keep their jobs. And they start messing with Social Security, they're going to have a hard time. Now, does it mean that they're not going to raise the retirement age? Does it mean they're not going to, trade off an increase in the earnings limit for something else? I don't know. Is disability more in the chopping block than retirement? Yes, disability is the redheaded stepchild of Social Security because there's no real lobby for it. But, we'll just have to see. Zippy is 60 years old on SSD, have Meniere's disease and other problems. What's the chance of a CDR? At 60, not very great. I think it's very, very low at 60. I really do. Ray Nunya, you're welcome, Ray. On the site we used, so Sandra, one of our clients, about new meds, visitors, a way to see what info we gave you. I don't think there is. Now, that's a very good question. That is something Jen probably can answer more. It's on the portal. And actually, that's something we've been sort of talking about, maybe changing that so that people have access to what they've already sent in. All that stuff that, like, when we write the adjudicators, that is all part of your file. Whether it is part of the My Case portal that you could look at, I don't know. I honestly don't know. I suppose that could be shared, but Jen will have to get back to you on that. I don't know. But it is there. It's in the portal, and all you have to do is to, basically say share it, and it would be shared. In fact, let me just take a quick look here. I'm looking at some of the documents that we have uploaded. And I'm just going to see if I can. I'm doing this kind of in real time. Now I can't really I can't look at it. I have to download it. All right. Let me, it's a very good question. I don't know, but I know that shareable, and all this stuff is available as a shared document. So I'm just going to have to, let's see. Now, as I'm seeing, it looks like a lot of this is shared with you. So what I would do, Sandra? Log into the My Case portal and see what's there. If that's there, if it's not, ask Jen if we can make that shareable. It's easy to make shareable, just a one click. So that might tell you, but I don't know, because I just don't deal with that as much. Thanks, but yeah, good sport. Yeah, you got to laugh. Look, it's I'm a sports fan, but I don't live and die by my sports teams. I know a lot of my friends went to the University of Georgia, and they take it really, really serious. And of course, the Bulldogs are a pretty good team. But, I look at it like, I like my sports teams. I follow, the Braves and the Hawks and the Falcons a little bit, but, it doesn't really change my life day to day. But yeah, I enjoy. Actually, when I watch a football game or a baseball game, I appreciate good play. And so if it happens to be that the Mariners are playing really well or the Cubs are playing very well, that's to me more interesting than, watching a mediocre team not play well. when you watch sports and you see bad basketball, let's say you see the, at the end of a season, you see the, Sacramento Kings playing, the whatever other team, and they're both of them are out of the playoff hunt, and they're just dialing it in, mailing it in. That's not very interesting. I could put the Hawks in there. So Sacramento's playing the Hawks and neither one's in playoff contention, and they're just playing out the string. Not very interesting. I'm not saying if you're from Sacramento, I'm not picking on them, but that's not real interesting. But when you see teams that are, you're watching Boston, you're watching New York, teams that are in it and they're intense, that's a lot more interesting. Actually, I enjoy watching women's basketball. I think it's a lot more fundamentally interesting than the men's game, the professional sport. Caitlin Clark, obviously has made people real interested in it, but I think the women's game is really interesting. My daughter played competitive basketball for years, AAU basketball. And so we watched a lot of girls basketball, and, it's fundamentally, girls obviously aren't going to be dunking, and it's not that many times are not as athletic just by pure athleticism. They got to get by on passing, on good shots and things like that. Even at the pro level, I think that's the case. But it's actually the pro women's basketball is vicious. I mean, these women are they're going after each other, and it's interesting. It's really very interesting. I just think the fundamentals are a lot more sound. The NBA is interesting. Now when you see certain players, Jokic is really very interesting. What's his name? Stephen Curry, very interesting, fun to watch. Some of these guys, but some of it is not that interesting. But it is, the athleticism is pretty amazing, pretty amazing. But yes, Shub, I have, I enjoy watching interesting sports when I'm watching it. I've been watching a lot of Wimbledon. That's going on right now, and that's watching those guys play, because I play tennis. You just see it's a different level. I mean, it is amazing the skills these guys have. It's incredible. Thank you, Christina. Appreciate it. Jim, so the videos help you. Great. I'm glad that the videos helped you. That's why I put them out there. I got more coming. I'm hoping to be able to knock out a few more this month. Most of my hearings will be done by the end of next week, so I'll have a couple of weeks where I can focus on doing more videos, which I enjoy doing. I'm just so busy doing hearings, which I'm not complaining about, but I'm so busy I don't just do too many of them lately. Can we have training on what you're explaining about AI for SSD, at what level it may help? I'll probably do some videos, some screen capture videos about that. Sure. Just and just show people what I'm doing, just about, and really it's pretty easy. I mean, just like I said, you find it. The big issue with AI, I will tell you, in my opinion, is that a lot of AI engines, and I'm talking about ChatGPT or Perplexity or Claude, or, just there's a bunch of them out there, that they're not private. And so they train the engines on the information people upload to them. And so if you're in the free versions, a lot of these are not private. So you don't really want to put your orthopedic records or your gynecologist records, upload them to the internet. Is anybody going to really look for them? No. Is it something anybody's going to really probably find? Probably not. But who knows? And, once it's out there, it's out there. So I think that, and, I just think that, when you have an engine that's a paid version and you tell it, do not save history. And again, Notebook LM is really good about this. I think it's a lot safer, and you can still, take advantage of the AI engine's brain power, as it were. And what's interesting about AI is you ask it a question, it'll give you an answer, then you say, well, that's not good enough, I want more. And you have a conversation with it. I'm actually in an AI mastermind group right now, with this guy, Ernie Svensson in New Orleans, and there's a bunch of attorneys, and we're all using, different AI engines just to learn how to use it. And it's really more about training your mind. It's just to think about this. This is not Google search, where you went to Google and you type in, whatever, herniated disc, and it would give you a definition. This is like a conversation with a machine. It's like having a brain sitting next to you. An outsourced brain sitting next to you, and ask it for things, and it's easy to get overwhelmed. It's easy to just not even know where to begin. So I would tell you, and to answer your question, it's first, I'm not really in a position to train anybody because I'm still learning it myself, but I would say, when I probably put some videos out there, it's really about just getting your mind to think about, Perplexity or Claude or Notebook LM or Chat GPT as another being, another person that you're asking questions to. Why would ask it, why would a bulging disc be less convincing to Social Security than a herniated disc? And it'll give you an answer to that. And you can ask it, here are my conditions. What do you think Social Security will do with it? Again, it's going to give an answer based on what it knows. It's not going to give you the same answer I'm going to give you, but it may give you things to think about. So it's a tool. And those people who say, well, it's going to take over all these jobs. Yeah, there may be some jobs that it eliminates, or maybe some law jobs it eliminates. There are certain simple tasks that you don't really need a lawyer to do, a name change, maybe an uncontested divorce, that AI may do. But what it's going to end up doing is it's going to be a tool that you can use to be more efficient, or as an attorney, I can use to be more efficient. So it may help me summarize medical records faster. It may enable me to access an MRI that I didn't, that's kind of hidden in the record. I mean, like right now, when I'm looking at a record, it's a big PDF file I've got on my computer. And so I use, a paid version of a PDF reader that's got a search function. So if I want to search for, I'll put in there MRI, lumbar MRI. It'll pull up all references to lumbar MRIs. That's not AI, that's just a search function. But that's extremely helpful, because before that, I would have to manually go through, 1,200 pages of records looking for an MRI report. Much easier to do it by search. Now, if I have an AI engine, I can say, who did the MRI, when was it done, and what did it say? It'll spit out that information. So it's just a more robust way to find things, and you have a conversation with it. So that's what I'm thinking. Jim says you had a hearing on the 5th of last month, so June 5th. Yeah, we're getting to that point now. It's July 3rd tomorrow, I think, where you should be hearing something. 4 to 6 weeks is not unusual, but I would say if you don't hear anything, by the last week in July, then I would maybe contact your attorney and find out what's going on. I think, Sandra, we've already talked about that. Memory problems, yeah, long COVID can definitely do that. Again, Social Security seems to be more focused on the cardiac and the breathing issues, but long COVID, memory issues can be part of it, and we can make that argument, certainly. RD asked ChatGPT to write notes, medical symptoms and impairment to give to my doctors. It's helpful, yeah. It can really, again, like anything else, what you feed it is going to determine what it comes out. But yeah, you can use it. Let's again, Notebook LM is a great thing for this. Let's say that you have a pain diary, and you can upload that to Notebook LM, and you've got your medication list. You can ask it to kind of give a summary of what's going on. It will put it all in kind of a nice, neat package. That's what this can do. But you also have to be aware that, AI engines they call it hallucinate. They can make stuff up. They're known, one of the things I've learned in my mastermind group, they're known for messing up pages, where it'll say it's on page 63 when it's not on page 63. So, it's not a perfect solution yet. Dreamers Club use ChatGPT as practice ALJ questions. Yeah, so if you go to ChatGPT and say, what are the most common questions that an administrative law judge will ask me in my disability hearing? That's a useful thing to do. At the worst, it'll give you questions you won't be asked. But at best, it'll give you some things to think about, because there's enough information out there where, it knows that, ALJs are going to ask about how long you can walk and stand and things like that. That's an example of using, an AI engine to supplement what I do as an attorney. I may do the same thing, and that may be part of my list of questions. Honestly, I'll tell you what I do. I have a list of questions on a document that I've been putting together over the years that are questions I want to make sure get asked at every hearing. Again, sitting, standing, walking, lifting, carrying, things like that. And if something comes up new, I'll add to it. Well, I could put that list of questions into Notebook LM or Chat GPT and say, are there other questions I'm not thinking about? And that may be things I can add to my list. Now, the list I've got's worked pretty well for me over the years, but yeah, always want to improve it. So that would be a good thing to do. But yeah, I mean, I have this document sitting next to me at my hearings, and as the judge asks them, I'll check them off and if it's relevant, and then I make sure that it's covered because I got to make sure all that stuff's, in the record. My pre-hearing brief and how to give detailed examples of my severe impairments. Yes. Yeah. I mean, I think that a pre-hearing brief is just arguing, it's setting out the facts. It goes through the 5-step sequential evaluation process, and it explains, has a theory of disability. I'm arguing grid rules. I'm arguing functional capacity, just kind of summarizes everything, very quickly. And I think that judges like it because it saves them time. My hearing today, we talked about, and I didn't think certain things were past relevant work. The judge says, I agree with you, and I didn't have in that case, I did as an opening. Normally it was a brief. I couldn't do it for some certain reasons, which I'm not going to go into, but I did as an opening. But the judge says, yes, I agree with you. This is not past relevant work because the earnings are not great enough. Putting that in a brief, just makes the judge's life easier. It also sends a message to the judge that I know what I'm doing. That's honestly one of the main reasons I do a brief in almost every case. Let's see where we're at here. Rip. Happy birthday, Jordan. I hopefully have pizza today. I did not have pizza today. There is a couple of slices of pizza in the refrigerator, but by the time I finish this, it'll be too late. But I did have some pizza this weekend, and there's probably a pretty good chance there'll be pizza on the on the menu this weekend. I like pizza. I'm actually a kind of a purist. I like cheese or mushroom. I don't like a bunch of crap on my pizza. I just like it pretty plain. There's a really nice pizza place, this guy from New York, not too far, Piccola's Pizza, not too far from where I live, and really, really good. And we have some friends coming over, so we'll probably order a bunch of pizzas, and then there's a bakery. And again, I don't get too far afield in it, but there's a bakery called Rhodes Bakery, which is not too far from here, that I literally have been going to this bakery since I was a little kid. And they make the most delicious cake, yellow cake, chocolate icing. And so it's sort of a known that, Jonathan gets a Rhodes Bakery cake for his birthday every year. So hopefully my wife and children will fulfill that requirement. And that was some vanilla ice cream and pizza. I'm not a fancy guy. That's more than enough for me. So hopefully there'll be cake and ice cream on the menu, as well as pizza. I'm not sure. I think we're doing some stuff this weekend, and then next weekend maybe going out with the family. So anyway, if an encyclopedia and predictive text had a baby, yes, that's right. That's exactly right. Exactly right. Smash that button, Christina says. Yes, smash it. Waiting for reconsideration in New York since March 1. Again, assume 8 to 10 months. New York is not the worst, not the best, but they're not the worst. I wish I knew you were on sooner. Normally I go on, Julie, at about 8:30. Tonight I went on at 8:45 just because I was playing some tennis, and I just wanted to, it gets dark later here, so I wanted to finish it up and not have to rush, even though I was sitting here at 8:30, but I was just wanted to, have a protein bar and just kind of relax a little bit. Okay, I got a letter from Social Security saying my application was denied because my lawyer didn't submit the form about work. Pending 2 months, you never told me. Is that normal? No, it is not normal. But you can appeal and, go to Recon, and it'll get in there. I was processed from pestering. You're not pestering me, Jim. Honestly, people say to me, I've had people say this to me and other attorneys, you as an attorney, you purposely cause this to be delayed so you make more money, or you purposely aren't telling us information. Not true. I mean, honestly, I have so much work right now. I always can take more. I got plenty of work. I am busy as can be. I got plenty of really good cases and good clients. I do this because I want to share what I know. And like I said, if I can get a case approved early, I will do that. I am not it just doesn't make sense for me. You know, if somebody gets approved early, um, and I'll get paid, you know, what I say to them, write me a nice review, and they always do. And I've got 250 really good Google reviews, a bunch of Avo reviews. That is currency. That helps. So even if I don't get paid on a case every once in a while and I got a good review, I'm cool with that. And at the end of the day, you know, karma, good karma. I'm helping people, goes out. So good. Happy birthday, says Christina. Been a year last year, out of town for your family. I think you went somewhere they had fish or something like that. Yes, well, typically we go, I don't eat a lot of meat. Again, I don't know if that, I don't have a problem with it. I just don't have a real taste for it. I'll have a hamburger every once in a while. Don't really have much of a taste for steak. Maybe every 2 or 3 years I'll have a steak. I eat chicken, but mostly I eat fish. I eat a lot of fish. I love a good trout, almondine. I like salmon. I like snapper, grouper, mahi. There's a great fish on the Florida Panhandle called triple tail. Like that a lot. My wife's a really good cook, so we make fish a lot. So we will go to a nice restaurant. You know, if we're going out to eat, I'll get 9 times out of 10, you know, I'll get fish. And yeah, a good piece of fish and, you know, baked potato or something feels great. My son paid the tab. Yeah, my son is actually a pretty generous guy. I mean, I sometimes give him a little bit of grief on here. He's in his early 30s. He works for Adobe, the software company. So he's makes a decent living, makes a nice living. My daughter's actually a clinical bioethicist for a hospital chain. She's a lawyer. So she's, you know, married with a kid and makes a good living. So, yeah, they're really good kids. And, you know, normally my wife will pay, but my son is, you know, pretty generous about stuff like that. He'll take me to lunch. That's just the way he's always been. So he's a good guy. He's a good guy. We, you know, my family, I'm very fortunate. Both my kids live within a couple of miles of me. I see them all the time. I see my granddaughter, you know, 5, 6, 7, some of 7 days a week. So, you know, it's all good, all good. Julie says, happy birthday. Yes. My rep asked for a second here. That's not uncommon. That is good. So, okay. Well, you know what? We are now pretty close to 2 hours. You know, I'm going to go ahead and end it now. Let's see, one more. The fruit does not fall from the tree. So, in some respects, yeah, I hope so. Look, I had really good parents, so you know, I'm very fortunate. My parents were. Hey, Madeline, how are you doing? Madeline is, you know, on hiatus with us, but good to see you, Madeline. Thank you for the birthday wish. I hope you're doing well. Yeah, you know, very fortunate. Had good parents, and my kids are great. Wife's great. So, you know, all is can't complain. Can't complain. A lot of people, you know, don't have it as good, and so, you know, having a good family is a great thing. So, anyway, Christina, yeah, that's right. My wife, yeah, she always reminds me how lucky I am. But no, she's a great cook and a great mom and great wife. So yeah, she's an attorney. She does workers' comp. Don't want to mess with her. Do not mess with my wife. She is her practice area is workers' comp, very, very adversarial. So she can be very aggressive when she deals with cases. So we're sort of wired a little bit differently, but don't mess with Jody. That's for sure. Did I meet? No, I met her in undergraduate. We both went to Tulane. She went to Newcomb, Tulane University in New Orleans. It used to have a women's college called Sophie Newcomb. They've now absorbed Sophie Newcomb into Tulane, but she went to Sophie Newcomb. I went to Tulane, so we met down there. I'm a couple years older than she is, so we met down there at Tulane, and that's it. I've been together ever since. Oh, good. I love great reviews. Thank you. Thanks. Appreciate it. Absolutely. All right. Well, listen, it is time to go. So everybody have a great 4th. Be safe out there. If you Shoot off firecrackers, be really, really careful with them. I know a lot of dogs don't like them. So, just if you got dogs, try to keep the dogs inside. My dog doesn't seem to care. Sadie doesn't seem to care about firecrackers. But if you can do them, be safe because they can be dangerous. And, enjoy the 4th. I know there's a lot of division in our country and a lot of people have very different political views. But when you step back and you look at it, we still are in a pretty nice place to live. I mean, we don't really have any threats. We got oceans on either side of us. We have relatively friendly countries to the north, maybe more so a few years ago, and to the south. We have opportunity here to make things of ourselves. I've been to other places in the world where you don't have it. So, we should all step back and maybe step aside from the political rhetoric. And I personally, I respect people's opinions. They may differ from mine in certain things, but I think you got to listen. And so I'll leave you with that. It's just, even if you disagree with somebody politically or religiously, whatever it may be, listen to what they have to say and you may learn something. And, don't go into things with a closed mind. Always have an open mind. As a lawyer, we learned that there's two sides to every story, and that even the most ridiculous, side of something, an argument you completely disagree with, there may be a tiny grain of truth in it. And if you don't listen to it, you never know. There was a famous, and again, I'll leave you with this. There was a famous movie a number of years ago called, I think it was 12 Angry Men. And it was about a jury. I think it's been remade, but the original one had like Henry Fonda and all these old time actors. And basically it was about a jury. And they heard a case and that you saw what was going on in the jury room. And the first poll they took, the first vote they took, it was like 11-1 in favor of conviction. And the one guy would not budge. And over the course of the movie, he kept arguing his point. And by the end of the movie, the rest of them had come to his point of view and acquitted. And I don't mean to spoil the movie for you. The point, though, is that here you have these people that had this incredibly, absolute point of view. And because they had to listen, they were in a jury room, they eventually came to see another side. So are there two sides to almost every story? Yes. You may choose not to accept the other side, but listen to it. And again, we're in a great country and celebrate that on July 4th. So with that, I'll leave you. I hope everybody has a great 4th and we'll see you next week. Thanks a lot.